Welcome to our panellists and members of the public. We are in public session once again, public evidence session. Could I welcome the panel? And just before I ask you to introduce yourselves, just to explain for the benefit of any watching media, our panel is a slightly odd mixture today. In order to fit in all those giving evidence, we have two representatives of associations and Mr. Wales, who is here in a personal capacity. So if I could perhaps ask, starting with Mr. Hutty, just to say briefly who you are.
My name is Malcolm Hutty. I'm the Head of Public Affairs at LINX, the London Internet Exchange, which is a membership association for people operating internet networks in the UK, including connecting in the UK from abroad.
Thank you very much.
Nicholas Lansman. I'm the Secretary General of ISPA, which is the UK's Internet Trade Association. We represent about 220 ISPs, representing about 98% of the market by volume.
Thank you. Mr. Wales?
Yes, I'm Jimmy Wales. I'm the founder of Wikipedia, and as was mentioned, I'm here in my personal capacity.
Good. Thank you all very much. I'm sorry we are running slightly late. The last evidence session overran, interrupted by a vote in the Commons, and I suspect we may overrun slightly in this one too. Could I kick off by saying the government has identified two specific issues about the present law which it wants to address. It does not require communications service providers to generate and or retain communications data for which they have no business need, and it does not apply to providers based overseas. Do you consider that these issues need to be addressed in the bill, and do you think that the way that the government's going about addressing them in the bill will impact heavily on the operations of the industry? Whoever wants to
kick off by saying as far as the industry is concerned and our initial look at the bill, it's clear that it does extend and does not continue with its existing maintenance of what it requires to retain data. So the government is looking to increase its capability in a way that will cause a great impact on the industry.
Yeah, Mr. Hutty?
Yes, I'd break the question down slightly. The aspect about whether the issues need to be addressed touches on really the balance between the appropriate balance, the place to draw the line of the balance between the interests of the privacy in the individual and the interests of law enforcement and public authorities in acquiring data to use to support their legitimate missions. We really don't want to get into ourselves expressing a view as to a value judgment on where that line should be drawn. We understand that this data is extremely useful for legitimate law enforcement purposes, and that's right. At the same time, data is also intrusive, and there is a legitimate privacy interest. And where to draw that line is an important thing for Parliament to decide. We don't really wish to express a view on where it is appropriate to do that. However, as an industry, we feel that we do have a responsibility to provide the benefit of our technical understanding of the likely impact of this on that balance. So that when we hear the government telling you, as they've told us, that this is essentially just a minor technical update to bring the current powers into line with the change in technology, we feel that it's incumbent on us to explain our view that this goes very substantially beyond the existing impact in terms of where that line is drawn. Whether or not you should authorise that, whether this is justified by the security need, that's a matter for you. But we will say that this data goes far beyond what has been done in the past. I noted, I did watch yesterday's exchanges, courtesy of the webcast, and the exchange between Mr. Ellis in particular on this point, that I would like to say, make a few comments. If it was simply the case that the volume of data, but not its nature, were changing, then the fact that there was more being collected, but it was now a reduced proportion of the total, would indeed be, the relevant thing would be, well, it's less than it's a lower proportion of the total. However, what we're looking at under these proposals is not merely changing the volume of data that's collected, but also the nature and character of that data. So, for example, when the Interception of Communications Act was dreamt up, which set the framework, the basic idea of the separation between interception and communications data that was followed in RIPA, you're essentially talking about On the one hand, there's the content of communications, which is a window on men's soul, and on the other hand, there's an itemised phone bill, which is just a business record. But now, from communications data, if you look at just simply web accesses, you're seeing stuff which, if not content, is very much more likely to tell you a lot about the nature of the person. So there are three things. Stop me if I'm going too much into this, but there are three different types of communications data that we think that I would suggest one might look at. One is material that shows about the associations between people. So, for example, that shows that you, ladies and gentlemen, lords, ladies and gentlemen, I should say, are all related to each other, and possibly that would indicate that, my Lord Chairman, that you are the ringleader, because your office sends out the messages all clustered tightly together and therefore identifies that you were saying, this is the time when we will meet for such and such meeting or something. So that's association information. But then there is information that identifies stuff about the nature and characteristics and information about the person themselves. That might include, for example, the fact that, Mr. Mosley, you read Conservative Home and the Daily Telegraph. Mr. Brown, maybe you read The Guardian, may tend to signify something about your respective political inclinations. Simply knowing the fact, and I make this up, I'm just making this up, that Mr. Brown, that you were looking at the GMB's website and not the public website, but a private site, without knowing what it is, might suggest that there was some ongoing relationship between you and the GMB, possibly you doing a bit of political consulting and so forth. Baroness Cohen said before that she shopped at Ocado. Now, you asked whether or not the contents of your shopping basket would be included, and indeed, they are not. But the mere fact that you shop at Ocado might suggest something about your socio-economic category, and if combined with other communications data, might tend to corroborate that. But if we were to go to something much more intrusive, and which I think you might give much greater concern, the geolocation information. The location of where a communication is made from, if it's made from a fixed location, means just, oh, well, this is his home address or something. But in the world of smartphones, where that phone is asking maybe every 5 minutes for an update on whether you've got new email or to update my weather application or something like that, you're getting a track of where you are from moment to moment as communications data events. Now, that's not something that's normally tracked by the provider, certainly not centralised and made available in a way that would be meaningful. But under this draft bill, it seems to be within the spirit and intent of this draft bill that that's the sort of thing that could be done. And if it were the case that the communications data were to suggest that one member of this committee or somebody, while on a Thursday night they went home immediately to their constituency, but on a Wednesday night they went out for dinner in the West End and then stayed overnight at an address which the fixed line is not registered in their name or the name of their spouse, but in somebody else's name, then one might well think that kind of information was highly intrusive.
Okay, thank you, Mr. Hutty. You did go on a wee bit at length there, but nevertheless you opened up an interesting can of worms. We'll all want to explore in this point. So we won't leave the subject, but I'll hear if Mr. Wales has anything to say first in the opening question. Then we'll come back on to this 25% gap and content and data.
Yes, I just have one small addition to what has been said before. Mr. Hutty indicated that as an industry association, he didn't want to take a position on where these sort of lines should be drawn. As I'm speaking today in my personal capacity, I do have rather strong views on this, that we are talking about some very fundamental issues of individual rights, human rights, of privacy, and I think that whatever we may do here, we should attempt to do it. So to the extent these issues do need to be addressed from a law enforcement perspective, we should do it with the least possible impact on ordinary people who aren't committing crimes, who are simply going about their lives. The separation, and I'm sure we'll get into this later, between the content and the and the addressing information is much, much more difficult to do. I would argue essentially impossible. To find out a great deal about someone, you only need to know which blogs they're reading, which Wikipedia articles they're reading, which I consider to be a very personal question. People may be reading it for all kinds of personal reasons, not implicating them in any criminal way. And it's a very difficult thing to argue that we should be tracking that sort of information on ordinary citizens who have shown no inclination of any kind to be involved in a crime.
Thank you very much. The 25% gap, I'm not going to ask the question, I'm just going to ask colleagues to pile in on it, which Mr. Hutty has talked about. And I think you've... Oh, could I thank both ISPA and LINX for your excellent, detailed written brief. Absolutely fascinating. You've pulled no punches in it. You've been critical in many aspects of the bill. And if colleagues wish to continue to question Mr. Hutty and Mr. Lansman on the 25% gap, which the Home Office allege, and Mr. Hutty's comment that there's a huge volume of new information, I think we want further information on that. Is it Lord Strasburger?
Yeah. We've heard repeatedly about a 25% capability gap between what the public authorities, principally the police and the security agencies, would like to get their hands on and what they can get their hands on. Does that mean anything to you? Do you recognise that gap and that 25%?
Well, the figures they've drawn are obviously best guesses. We don't know how much data is going to be required to be collected because there's not a lot of clear information about the notices.
This is said to be a current gap.
But I still think it's a best guessed estimate. And when we look to the future, in terms of communication services, in terms of the actual data that would be collected, it could be vastly more. I think the important point is to understand better what is the meaning of the data they want to collect and what it would be used for. And that's the bit that we don't quite understand as an industry.
25% is a number that I believe they made up out of thin air. I don't think it has any actual basis of any kind. It's a rough estimate of something that is undefined. I don't see how we can even respond to a number like that.
I would ask 25% of what? 25% of all data, 25% of the data that we need, 25% of something else. I don't understand what this 25% figure is.
It was put to us as 25% of the data that they would like to get their hands on from time to time, but they can't.
I appreciate that, and I did actually watch all the sessions, and I have had private meetings with officials as well, seeking to understand this point, and I still remain confused about it. I don't wish to use the sort of language that Mr. Wales just used about thin air, but frankly, I just don't know how that figure was arrived at or could be arrived at.
Thank you.
I thought the impression I formed was that it was 25%. It was a loss of the kind of information they got in the old days, when all you were looking at was telephone communications and occasional interception of the mail.
But all that information is still available under existing legislation.
But because of the enormous spread of telecommunications, they're in fact talking about a 25% loss of a much larger figure. So I'm not sure quite what meaning it has, because I'm not sure what the larger figure is.
This is essentially a less inflammatory way of saying what I was trying to say, which is it's 25%. You know, if we're talking about new forms of data, such as your exact physical location every 5 minutes, that's so it's apples and oranges comparison. We can't say it's 25% more data. It's it's not just the amount of data; the kind of data is so significantly different that I think that a numerical estimate like that it's very difficult to place any meaning on
it. Balance Cohen, was it? Do you have a point on it? No. All right. Okay. Sorry, I don't know who was next. Oh yes. Sorry, Lord Strasburger, you're in question 2. Yes, sorry.
LINX's written submission raised concerns about the requirement for companies to collect third-party information, third-party communications data. Do you all share those concerns about third-party communications data?
Yeah, well, as far as ISPA is concerned, I think there is a a great concern. It's largely down to the lack of knowledge that we have of what is the intention behind the government in this. But third-party data is potentially an enormous amount of data, and if it has to be collected by UK CSPs, that will impact on the industry potentially in a very important way. It could be in terms of cost, it could be in terms of driving down innovation, it could be just confusion for companies to know what they have to keep and what they don't have to keep. So, you know, more information is needed really before we can make sort of clear statements and answers as to the effects.
Yes, I would say this is from our perspective at Wikipedia, this is a concern that we would have. One of the things that I think is important to understand is how trivially easy it is for people to evade this sort of thing. So we don't have servers in the UK. We would be highly disinclined to collect more data than we actually do, which is very, very little, for a variety of reasons, including our views on freedom of expression and human rights and what people are reading. But if we find that UK ISPs are mandated to keep track of every single web page that you read at Wikipedia, I'm almost certain, I shouldn't speak for our technical staff, we would immediately move to a default of encrypting all the connections to the UK, so that the local ISP would only be able to see that you're speaking to Wikipedia, not what you're reading. That kind of response for us to do is not difficult. We don't do it today because there doesn't seem to be any dramatic need for it or no dramatic threat to our customers. But it's something that I think we would do absolutely.
Just add to that, and by saying I think this is some of the information put in our evidence to say that this is the potential of this bill is to chill innovation. And if you have the example here from Wikipedia who's potentially willing to encrypt and to withdraw service from the UK, the question you have to ask yourselves is what will this be effect on other companies either coming to Britain, investing in Britain, or trying to start new innovative businesses in Britain. And this is, I think, some of the fear that ISPA has, that this without the knowledge of what this bill means, it potentially has quite a potential damaging effect on future innovation in the internet industry, which ultimately underlines and underpins a great deal of innovation and growth in the economy, affecting financial services, manufacturing, and all parts of industry which really are underpinned now by the internet industry.
I would say that this cuts both ways. The inverse is also true. Back about Christmas time or thereabouts, we were led to believe that what was being considered by the communications data team at the Home Office was to be focused not on the collection of third-party data and probes in the network and big database search facilities, but instead the focus was to be very much on seeking cooperation with the over-the-top providers that actually had the data themselves for legitimate law enforcement requests. And at that time, when that was our understanding, we had a very different view of this. And all the criticisms that we make, or concerns that we raise regarding third-party communications data, it kind of cuts both ways. If you weren't actually requiring that third-party access, and if you weren't building this enormous profiling engine that has so many challenges involved in it, whether they are privacy or technical, or cost of technical feasibility, or the effect on innovation, if you don't have those elements and instead focus on that aspect of this bill, which is about seeking to get such cooperation as one is able within the laws of on which the over-the-top providers operate, for legitimate law enforcement cooperation in the public interest, we really wouldn't have written the kind of submission that we have written today.
What's the effect of encryption on retention of this third-party data? Presumably, if the data is encrypted, you would not be able to differentiate between content and communications data. So if you were to retain it all, would you not be at risk of retaining content?
So just to clarify, if I am a UK-based bad guy, and I think I have heard that the government is snooping on everything, what I would do immediately is open an email account, trivially, at any of thousands of free email account providers around the world. And by default, the communication for email is encrypted, so that the only thing that you would be able to see from the UK service provider would simply be that I'm talking to this particular email service. You couldn't see the content of the communications at all because it would all be encrypted. If you saved that data, I suppose you could try to crack the encryption and so forth, but that's non-trivial to say the least.
What is your understanding of what the requirement of the Home Office is for the retention of encrypted data? Will you be required to retain it or not?
We don't fully understand that. I can't give you a direct answer, I'm afraid.
And is this requirement to retain third-party information likely to encourage more and more information to be encrypted?
Yes.
Mr. Wales has already answered
Yeah,
that.
and in fact, this is a broader trend in the industry for lots of reasons. These days, Facebook, as an example, offers encrypted connections for people for perfectly valid reasons of security. If you're using Facebook on an open Wi-Fi network, it was discovered a couple of years ago, people could snoop and copy your session and view your Facebook page. As a response to that, more and more providers are encrypting connections. It's becoming less expensive to do that, and there are certainly good, sane, rational security reasons for doing it, so that people along the way can't sniff your communications. That is an ongoing trend which will continue and be pushed forward, I think, the demand for that kind of thing by laws such as this.
I think you can see this as a trade-off, because the very fact that you can encrypt is very good for stopping fraud, making sure banking communications and transactions are safe. But at the same time, it does make it harder for law enforcement to access this sort of information. So encryption is actually a very good thing for the customer, for business, but it does have the other side effect that, of course, it does make it harder to look at.
Well, to look at information that's passing over the wire, it makes it hard to do the third-party data access. But going back to what I was saying before about our previous hopes that the main focus would be on the third party, on the over-the-top provider, to actually ask them, well, they may be an encrypted channel between the user and that provider, but once it's reached the provider, it's no longer encrypted, and they have access and could cooperate to the extent that they're able within the regulatory regime that they operate under. So again, and as I say, the Home Office continually tells us that no, the main focus is there, but that's not what we see in this bill.
And for Mr. Wales in particular, how do you see any change arising in the behaviour of internet users if this bill were enacted?
Well, I think it will encourage people to use services that are not based in the UK. I think one of the biggest impacts that we should be concerned about is what does this do to the UK startup industry, as the costs are substantial, even though the bill contemplates compensating for those costs. I can tell you from my own experience, in the very, very early days of Wikipedia, we were growing very quickly. We actually stopped logging all accesses for quite a long time simply because we could not afford the server space to keep up with them. We certainly didn't have the resources to have a full audit of our security system in order to get compensated by the UK government for, we just had no resources to even think about that sort of thing. And this is quite natural in the days of a startup. So we're going to have two things. We're going to have consumers who think, gee, I've heard that the government can snoop on my email account if I don't get one from the US. And two, potential investors and entrepreneurs here in the UK will be faced with quite a burden of dealing with complex regulations to store data that they wouldn't otherwise store for business purposes.
Dr. Hubbard?
Can I just press briefly on this issue about encryption? Because I think it actually is critical to the success of the Home Office scheme. Because, as I understand it, the Home Office scheme is if people will give them the data from outside, that's great. If not, they will require CSPs to install black boxes to suck it out. As we've already heard, it will very quickly become encrypted, so it could only work if there was a way of breaking the encryption. And I'd be very grateful for a professional assessment from each of you. I've heard about things to do with fake certificates, about man-in-the-middle attacks and various other options. How plausible is it on that sort of scale to break any of these encryption technologies?
you want to take that?
Yeah, it all depends on how dirty you want to play. Certainly, the UK government could engage in a wholesale systematic effort to do man-in-the-middle attacks to capture people's internet traffic with fake signs. I mean, this is the sort of deep arts of black hat hacking. It doesn't sound like something that a civilized democracy would want to be involved with necessarily. It's more like what I would expect from the Iranians or the Chinese, frankly. Is it possible? It's not easy, and it would be detected immediately. This is the thing. This is not something that you could do at any scale without the internet community noticing it and sounding the alarm. People they check these kinds of certificates. Things do get exposed. It's mind-boggling to conceive of even thinking that this is a rational public policy.
Well, from a commercial perspective, it's that issue that it would be detected that would be probably the thing that would mean that it's not. I doubt, in all seriousness, that the Home Office is seriously contemplating man-in-the-middle attack type things, such as been speculated, because it would be detected, as you say, and the impact on confidence in business communications of real value would have to be weighed against the value for law enforcement. And I'm sure it would be concluded that the harm done to the economic interest of the UK outweighed any potential benefit.
But so the consequence of what you're saying is that if this bill were to go through essentially as it is, that section which deals with making CSPs collect transiting data would very quickly become completely useless, because all the data you are going to collect becomes encrypted, and then you can't get any of it anyway. Is that right?
That is my belief. And I think it's important to understand, often when we speak about encryption, man-in-the-middle attacks, this sort of thing, it's quite easy to imagine, a few people could evade this, but frankly, your run-of-the-mill terrorist, pedophile, etc., isn't that technologically sophisticated, and so we still think we could get a lot of it. If we think that way, yeah, that is absolutely true. For people to start using complex encryption tools, which they could do, it might go up a little bit, but that wouldn't be the main factor. The main factor for me is it's as simple as I'm not going to talk about things on Facebook or Google or the places where I know the big companies, the responsible companies, are going to cooperate with law enforcement. I'm just going to use a free email provider in a country that's not in the UK.
Actually,
it's quite trivial to get around it.
I have a different answer to that question, Dr. Hubbard. I don't think that it does completely undermine it. It prevents one element of the types of what's being sought here from being recovered. So I think Mr. Wales's reply there relates to things like the messaging that happens on Facebook, the messaging that happens on Gmail, which it would prevent. But if you go back to my opening statement about the different kinds of data, we would still know that you were shopping at Ocado, even though your communications with Ocado were encrypted. We would still know that you read Conservative Hume and the Daily Telegraph, and that Mr. Brown read The Guardian.
But we know that now, don't we?
Well, no. That's not something that is collected. It's not something that is made available. It's the email, telephony records are collected. Certainly the tracking of people around the city, the geolocation information, that would not be prevented from being gained by encryption, because which cell site you connected to with your smartphone connected is known by the network operator. So no encryption there is going to defend against that kind of thing. So certain types of communications data would still very much be available, and they may very much go to many of the things that I opened at the beginning. What it would impact on was the ability to track the more traditional messaging through the new technical means, such as Google Mail and so forth.
Baroness Cohen, and then we'll move on to...
It's a question for Mr. Wales. Is encryption very expensive? I mean, when you said that you would, if necessary, encrypt Wikipedia communications, have you had a shot at costing that? This would help my thinking. Does it come up very expensive or very cheap?
Very cheap. And I have not formed a precise estimate, but I could ask my staff and we can get back to you with that. It's not inexpensive anymore. There was a time when doing good encryption on the fly was difficult and expensive, but servers are very powerful now. It's something that when I use Facebook and when millions of people use Facebook, every page is encrypted. It's just an option you turn on in Facebook, which doesn't cost anything. It costs Facebook something, but not nothing material.
It's not an inhibition.
It's not an inhibition, no. And in fact, many kinds of communications are already by default encrypted. So, for example, when you download your email from Google, for example, that connection is typically going to be already by default an encrypted connection. And e-commerce sites are encrypted by default and things like that. It's not a big deal anymore.
Suppose then I sign up to Facebook and I tick the box for encryption and my messages are encrypted. Presumably they're using a standard encryption code or a key that if the government cracks one of them, they can crack the next couple of million. Or is every single message using a different code or page?
Closer to the latter. It's not like you just need the one password for Facebook encryption. Every session would be encrypted with a certain key that's generated. But we should remind, I just want to point out that using Facebook as an example is probably not the best, because Facebook already, for their own business reasons and their cultural reasons, they collect massive amounts of data and they save it forever. And consumers are actually deeply concerned about that. And of course, Facebook is a responsible company with operations in the UK. So if law enforcement wants to find out everything you've done on Facebook, they can just get a court order already. That's quite simple. And so this, it's not clear to me that this bill would impact Facebook very much. Of course, I don't know what the people from Facebook may have to say about that.
Lord Chairman, if you need details on that last, I suggest you direct them to Professor Anderson, who you've already heard from, who is actually a world authority on the subject.
We may wish to speak to him again. Can I move on to communications data and separating content and data? And Lord Armstrong.
You touched on earlier, I think, the difference between communications data and content. It's important in the bill, perhaps not least because communications data can be authorized without intervention by a judge or by the Secretary of State, whereas interception of content requires a warrant. I think we've been forming the impression from what you said that the border is very porous between data and communication. You talked about the accumulation of data, which told you a lot about. The other matter is technical. I mean, is it technically possible to separate communications data and content in your world?
To some extent, yes. There will be edge cases where it becomes increasingly technically difficult. There will be further edge cases at the extreme where it's actually conceptually difficult. So, for example, if I were to send you an email, the fact that that message was to you is communications data and what I write to you is content. If within that email I say, please could you pass this message on to my Lord Chairman, then is that the fact that that message that's included within it now communications data because it's actually you are going to be doing it? If it's written in prose, does that mean it's content? But if it's written in a manner that makes it easy for you to just click a button and it will do what I just said, does that suddenly turn it into communications data? So at the edges, there will be difficulties of understanding. Furthermore, the simple technical difficulty of having probes within the network that analyze network traffic, third-party network traffic that you don't know yourself and don't understand, but that you've configured that box in a manner that seeks to pick out those bits which are communications data and discard the content, depends on the idea that we understand the nature of that traffic and can identify those bits of it which are communications data, even though they're intended for somebody else. So, for example, can scan what is a web page transmission from Google Mail to the user, and to pick out of that web page, actually it's really just a web page that performs the function of an email, and within that email there is a line here that is a to line or a from line or so forth, and that is communications data, and to pick that out. And to be able to understand that that web page is actually really an email, and that this element, this particular email address within it, is a communications data element, whereas this other email address, which is maybe in my signature of my email, is not, and be able to distinguish between those two. And continue to be able to do that every time the provider, the over-the-top provider, such as the website concerned, changes the design of their web page. Those boxes need to be reconfigured so as to be able to do all that again. And then if you extend that into other kinds of other protocols, so for example beyond web and email, but into things, I mean the Home Office's consultation paper before spoke about being able to understand when people are chatting to each other in computer games. Well, there you don't have anything like the same simplicity that even in the complicated question that I've just described. There you have to understand you've got a computer game client that's written by a private company, the game server that's written by the same private company, that's using its own protocol that's made up and maybe changed from day to day by that private company. And you're trying to guess which elements of it out of there amount to communications data and program that box so as to be able to do that. So there is an element to your question, which is, are we going to be able to do that in practice? And I think that is going to be an enormous challenge, an enormous technical challenge, at the to put it at mildest.
Sorry, could I just interrupt? Can you clarify? You said games, so kids or people playing with Xbox or Nintendo can communicate?
Oh, yes.
And you can send messages through Xbox and Nintendo?
That's right, yes.
Good Lord. Okay, sorry, Lord Armstrong.
I might also say that the most popular demographic for playing such games is no longer children.
Ah, right, yes. I apologise to 10 million people I've offended.
It goes to the relevance. Is this just something at the margin that, but let's face it, we're not really going to be interested in law enforcement need on looking at what the children are saying to each other? Actually, no, we're talking about young men of maybe 18 to 35. Actually, their communications might be of interest. But it's going to be extremely challenging to be able to acquire it in the manner envisaged by the bill.
So you're suggesting that potential bad guys, Al-Qaeda in future, could be using things like Nintendo or Xbox, which would not be caught by this bill?
They would be caught by the bill in terms of the intention. That's why the bill is so broad, as to try and seek to get anything, including mere computer games.
I think the point was
but it's going to be very difficult to actually deliver on that.
Yes, but unless the Home Office were to serve the orders on them to comply and install the DPI boxes and so on, they might not be caught that way. That's what I meant.
Oh, well, yes. I mean, the Home Office would have to decide that they were going to set us that technical challenge, yes.
Okay, sorry about that. Lord Strasburg, do you want to... No. We're moving on. Baroness Cohen, was it? Question 6?
I think we just missed question 5, but I think we got the answer.
My apologies. Yeah.
Which was to ask you generally if you thought that this was going to damage relationships with service users, for users to know that companies are retaining and sometimes disclosing stuff to the Home Office. I mean, I guess do we think that's a real, that the extension of this bill is going to make people very leery?
I think it would impact on the nature of the relationship between the service provider and the customer. I mean, there's something in the precise phrasing of this question that signals to me that you're asking, do I think it would be better if we kept it secret? And I'm not sure...
I was going to ask it the other way around. Would it be better if we made the Home Office public?
I'm certainly not sure that it's possible, really, to keep it entirely secret, in that if you think that the customer might be upset at something you're doing, so you try to keep it secret from them, and then it comes out in the open, then they're even more upset. So it might not be a wise public relations strategy to go down that route. That would be a matter for individual businesses, of course, to consider if the possibility is available to them, unless you decide to make it very open. An alternative route would be, as you say, to bring things out into the open, to say there is a legitimate need for so much and no further, and we will have that as a democratic debate, a justification, a parliamentary approval, and then providers simply comply with the law. which is fine insofar as it goes, but it does impact on the nature of the relationship with the provider. The providers have always provided support for communications, of the communications data, but the nature of the material that we spoke about earlier, essentially when you're talking about things like phone call records and so forth, you're essentially talking about a business document, and really the nature of the cooperation that's been given there can be seen as, can be characterised as, well, any responsible citizen, if they come into possession of something that is necessary for an actual law enforcement investigation, should of course help with that. You know, just like being the witness to a crime. Yes, you tell the police what you saw. And similarly, if you've got this communications data, then you hand it over in that fashion. But you don't necessarily go out looking for things that you don't already have a business need for, that you haven't got for your own proper purposes in serving the customer. That's more like joining the police on a stakeout. And that's not what most ordinary citizens do, even corporate citizens. Now, it's not entirely without precedent. Communications providers have always supported lawful intercept capability.
Yes.
And that is going beyond just something happened and therefore we'll cooperate. No, that is providing a specific design service to support law enforcement needs that is very proactive. But the lawful intercept capability is a very limited thing by comparison to this. Most people are not going to have their phones out.
Sorry, I need to shift the focus of my question a little. I mean, Mr. Wales, you come at this from a slightly different angle. I mean, you think it would damage your relationship. Presumably you feel that it would damage your relationship with customers if the Home Office suddenly arrived on your doorstep. Not that you will ever, not that you have the power to do that directly. And that's why you'd encrypt Wikipedia.
Yes.
Is this partly a moral decision, partly a commercial decision?
Well, in our case, as we're a non-profit charity, we don't normally think about commercial things. I suppose we do know that our user base is quite passionate about freedom of expression, privacy, and this sort of thing. So as a charity, I don't think it would hurt us commercially. We would probably get donations from people who feel that we've made a courageous moral stand. But in general, I do think that one of the things that we really put forward, we try to make people feel comfortable about, is that, what you read, what you want to learn about is very personal and very important, and we don't give out that data lightly. In fact, we don't keep very much of that data at all. We do keep extensive data on when people are editing Wikipedia, of course, because we have to deal with bad behavior and things like that. And we cooperate with law enforcement. We will always obey, of course, a U.S. court order, but we'll also cooperate with law enforcement overseas if it's the naturally, obviously, sensible thing to do. We feel that it's very different, a situation where if you have a judge who's ordered to keep track of something, or a judge who's ordered a specific inquiry on a specific thing, is very different from, and this is where I get to the answer to your question, a broad program of storing large amounts of data that we wouldn't otherwise on innocent people. Because we do think that undermines the humanity of what we're doing. We're writing a free encyclopedia and giving it to the world. It's our gift to you. It's not our way of surveilling you. And you should feel comfortable when you're reading Wikipedia that it's your own personal business. So that's sort of the way we come at it.
Very interesting. Can I have a go at a slightly more technical question? You said that you thought the need to encrypt would inhibit innovation. If people had to think about that. Do you think that it would impede innovators like yourself if you'd had to think about keeping data for the law enforcement authorities?
Yes.
Arranging your life like that?
Even
as a technical question, not just a moral question.
Yes. So from a purely technical and business process point of view, for a small startup, you really, in order to be successful as a startup, you really have to be incredibly passionately focused on what it is you're building, what it is that the customer wants, what it is that's going to be useful and practical and people will enjoy using. And many of the most successful startups began with a team of 2 people, 5 people, 1 person, and to impose on them a requirement, a separate requirement, to keep data that they wouldn't otherwise keep, but also keep it under conditions of security which are, as a moral and legal responsibility, quite onerous, and to design your entire system around that. Well, if you're not being compensated for it, it's obviously a huge barrier. But even to be compensated, if we think of any realistic program of government compensation here, we'll have to guard against people who set up businesses simply to milk the system by gathering data on people and say, now you've got to pay me to stop, or to take care of the data. And so that means I'm going to have to interact with a set of regulations and a set of audits of my processes. It's hard for me to conceive of how you could do that without having a team of people working on it. In a small startup, it's not really conceivable to think about how you could do that. It's much easier to move to Germany.
That impact isn't limited to small startups. You can speak to a large company and they can have a whole department devoted to this, and their jobs depend on, oh yes, we'll work to implement all this stuff, and everything seems great as a steady state. But when you take on board an obligation like that, you're not simply taking on board the duty to do it now, but also that any future changes that you make, any new developments that you make to respond to maybe these small startups that are trying to eat your lunch, they must also be compatible, and everything you must do must have this new thing built into it before you can get started. And if you wonder why sometimes small startups appear more nimble and larger companies sometimes seem a bit slower to act, it's because they have so much that they must also, anything new that they do must fit in with. And when you start layering on incredibly complex and burdensome technical requirements, even if fully compensated for their ongoing thing, it limits their ability to react to market demands.
Yes, Mr. Lansman, you represent over 200 companies, large and small. Is that your view as well? The impact
it is.
of innovation cost?
I think it's a very fair point that both my colleagues have made, which is the effect for different reasons will apply to very large companies and the smallest ISPs. I mean, ISPA is made up of the top 10 large communication service providers, but equally have a large number of smaller companies who provide business-to-business services to a large number of British businesses, SMEs and upwards. And I think they, for different reasons, will have concerns about this, waiting for the notice to come, which may or may not. It may be that the Home Office is focusing on the larger providers at the start. But if you're running a business and to think you've got something maybe coming around the corner that says you now have to comply with this law, that's a worry. And if you're designing products and services for your business customers, your then focus will be on actually thinking about an obligation to retain data rather than providing efficient, innovative and cost-effective and speedy services.
Or answering the question,
And that's, I think, a distraction.
In this context, I think it's important to focus just for a moment on the numbers that we're talking about here. The number of £1.8 billion over 10 years, so 180 million pounds per year, which I think is an underestimate. Maybe I'm just a bit cynical about government estimating numbers, but as we all know, these things do tend to go up. The British Private Equity and Venture Capital Association, I looked up the numbers of their members. Their total investment in the internet industry in the UK in 2011 was £37 million. And so when we think about the magnitude of what we're asking here, £180 million expenditure on building a system for collecting data, how does that compare to the total investment in innovation in the UK, which is even at that fairly low level? And I should point out, BVCA represents the venture capital industry. There's a lot more venture investment than that, angel investors and things like that. So I'm not suggesting that this is the whole of the investment. But if we start to think about the magnitude of what we're doing as a society, do we really, and even this small amount has generated a lot of excitement about the Silicon Roundabout and the Shoreditch startup scene. To me, it boggles the mind to think that we would spend this much money in this way when we all feel that investing in startups is something that we should be doing more of.
Okay, thank you very much. Mr. Mosley on the filter engine.
Yes, within LINX's submission, there's a big section on the filtering arrangements, what you call the profiling engine, and you've talked about it in quite a bit of detail earlier. So I was going to aim it at Mr. Lansman and Mr. Wales. Just ask, what do you think about the filtering arrangements? Do you think they impinge on an individual's privacy?
Well, I think the first thing to say is we don't know a lot about it. We know it's called a filter. We know also in LINX's submission they've called it more of a profiling engine. People on the committee have called it a search engine. I think knowing more about what it might do, it sounds when the government presents it as something that's quite innocuous, and the object is to actually stop government getting too much data that it shouldn't look at. But of course it could be used the other way, and I think the fear without the knowledge of what precisely it will do will be that it will actually look at data from different people and will be able to make, I suppose, judgment calls, and that is, I think, what's of concern not just to ISPA and us, but to the average person in the street.
Yeah, I think that one of the concerns that people have had in the past is the notion of a centralized database. And so this scheme is in part supposed to allay our concerns about that, because all of the data will be held in individual databases. This raises other questions, because the more individual service providers have databases, the more chances that somebody's going to be sloppy and let loose some data. But this search engine profiling point, the filtering, this becomes quite a very interesting point of attack for anyone who's trying to gather information about an individual. And if we're gathering data willy-nilly, indiscriminately on everyone, not just people who are criminal suspects, suddenly we have a system where someone could make a request and get, huge amounts of information about an individual. That's seems like something very risky to have, and whether it's technologically stored in a single database or it's some kind of interface to a lot of different databases, it's a concern. But as Mr. Lansman said, we don't really know enough about it to fully understand it. I would be concerned about I think I'm in the wrong room to bring up tabloid newspapers. I think that's the Leveson inquiry, but we've seen quite unfortunate circumstances of people paying for information from police, and how much more tempting is it rather than asking the cop, which celebrity went in this restaurant, to say, could you get the entire, I'd like all of Rupert Murdoch's emails, please, or just the communications data around it. To me, it just seems like a very dangerous thing to have available, and that doesn't mean that we can't keep it secure, but it's a serious concern.
Talking to the witnesses, we've heard that there is some concern that there might not be a direct tie-in between the data which is held by yourselves or the companies that you represent and the eventual evidence that the police, whoever it is, actually uses in court. Do you share concerns about the transparency of the filter results, and whether those results will then actually be able to be used as evidence in future?
I think that is one point that both LINX and ISPA have made, is the more you interfere with databases, query it, mess around with it, there is a danger that the data becomes less evidential of a level of quality the court would be able to prepare to accept. And I think that is a risk. Having said that, it may be that law enforcement are looking at this to provide intelligence that may well be of very important use in sort of tracking crime, and it's that debate that we've mentioned earlier. Is what is proportionate in terms of inquiry of the data to solve some very bad crimes, and I don't think for the industry to ask these questions. It's for Parliament to properly scrutinise this and ask the questions of, is this level of filtering appropriate? Is it what we need to track down appropriate crimes? And if it is, then fair enough. But if it's too intrusive, that's a decision that not the industry should be taking, but Parliament.
Okay. And within the draft bill, it gives powers to the Secretary of State to transfer the functions of the filter to a third party. I think it is a designated public authority, but I don't think it's too clear on that. Do you think this would create a more arm's length approach which might be advantageous, or do you think it might actually be to the disadvantage and create problems?
Well, I think, I'm sure my colleagues will chip in here, but the initial points you've made is abrogating authority to a public authority, abrogating this responsibility is not always a good thing. And again, I mentioned it earlier, having some sort of parliamentary oversight of this process, just to hand over a lot of power to another public authority, is not necessarily a solution.
Maybe I should chip in. The Home Office is not an investigating agency. It's a central government department. So I really wouldn't envisage the Home Office implementing or running this facility, this profiling engine itself. There would be some agency that would be tasked with it or created for the purpose, and you've got mechanisms in the bill to handle that. I think you would want to divide out the different things that need to be done here. There needs to be the creation of policy. There needs to be the operational use of this facility, if this facility is to exist, and there needs to be some oversight of it to ensure compliance with policy, to discover non-compliance and to correct it. There are three different functions. The operational side should be separate from at least the other two. There are models that you could consider which had the policy setting side and the compliance oversight side both either together, that's kind of how the Financial Services Authority works, for example, or separately, which is rather how we have in RIPA, the Home Secretary currently sets policy, and the Intersection of Communications Commissioner has the oversight function. So you can put those two functions together or take them apart, but you really have to have the operational side separate from either of them.
And would you be able to suggest what sort of authority or which authority
No,
has
that's not really for us to say. I mean, this is essentially, how you organise the police, law enforcement, in the round, intelligence, community, all being served by this function, and that's really beyond our scope.
Some others have suggested that if setting the filter parameters or programme it were left to GCHQ, that would be inappropriate in a democracy, since they stem from a sort of military background, quite rightly, spying on overseas dangerous characters and military threats, and that it would be better placed with the police, for example, who may be slightly more accountable, or a lot more accountable, to Parliament and to local democracy. Do you have a view on that? Any of you have a view on that?
I think that if you want any accountability in this, you need to set a framework for that accountability to take place, including some basic value judgments as to where lines are to be drawn. We don't seem to have in this draft bill a mechanism for that to take place, which is one of the reasons why we're critical of the level of parliamentary scrutiny that is proposed under the bill, and in the answer to the question that you gave on that subject. So I think it's not so much a question of who does it, but what are the frameworks? Who's going to oversee it? What are their powers going to be? What rules? In which areas should rules be written? Yeah. What kinds of rules are going to be required? And something that gives a parliamentary steer on this issue of proportionality, of what is considered proportionate.
It's quite unusual to hear an organisation representing 450 private companies wanting more parliamentary scrutiny or interference, but I did pick that up from your written text as well. What about the Information Commissioner's Office? I think you've been reasonably critical of their role so far, and how do you see their role in the future? And in regard to that, how would you change it to satisfy the demands for scrutiny you've suggested?
I think you were referring to the Interception of Communications
Commissioner.
Commissioner.
Interception of Communications, yes.
As I say, as we said in our written material, the role of the Intersection of Communications Commissioner is not entirely clear, but can be inferred somewhat from the way that function has been carried out, and appears, by the nature of the reports that have been written, to have been largely focused not on the broader questions which I've posed back to you, but instead on a narrower question of can we be assured that there has been no widespread misuse of RIPA powers, which is a perfectly proper thing for there to be oversight of, but does not necessarily extend to the full range of oversight that you might want of covert investigation policy.
So you're suggesting that he looks to see, is this in compliance with the current law? Yes, it is, not whether the current law is now being exceeded by technology or whatever.
Indeed, and some of the questions about, is it justified to ask for richer kinds of data? Is it appropriate that we should be treating geolocation data as mere communications data rather than more similarly to content? Those sorts of questions are the sorts of things that actually the Information Commissioner has a habit of raising, not in this area, but by analogy. The Information Commissioner has a habit of raising questions about the general framework of data protection and of stimulating a debate in Parliament on these topics. I've never seen the Interception and Communications Commissioner in this area do any such thing.
So would you advocate a new body or really beef up the Interception Commissioner's role?
I think that would be going beyond my mandate to suggest a specific thing there. I would simply point out that there are a good framework of regulation in this area that actually delivers the legitimate law enforcement needs within a framework that people can be confident in, has certain requirements that I've set out in some detail in our written response. That need to be met, and they're just simply not present in the bill. They're left for later.
Okay, one final point from me. Consultation requirements in the bill. Do any of you have a view on strengthening the consultation requirements before orders are placed on any of your companies?
The requirement to consult the company on technical matters and the ability to appeal the results of those discussions to the tab is welcome. Firstly, to ensure that actually things can be done at all. That's gone. And secondly, to ensure that they can be done in the sort of cost framework that's being discussed. So that's essential. But your question asks or touches upon something more broadly, which is beyond the direct the technical feasibility of actually implementing a specific requirement and the direct financial cost of doing that one thing. Is that the full extent of the company's interest in the matter? And we would argue no, that we also have an interest in matters like in the proportionality of the collection at all, because it impacts on the nature of the customer relationship, that there's a broader financial question of unrecoverable costs that I've gone into again in some detail in our written thing, in our written material. That really goes beyond the scope of what you could discuss in those consultation and beyond the scope of what the tab is allowed to consider. So it's not going to be open to us in those to our members in those consultations to be able to say, no, this is just becoming too much overall of a burden for us, or it's diverting us too much from our mission, or that it's undermining, or that all our users are fleeing to our foreign competitors because they don't want to use a service that's accessible in this way, or any of those things are not going to be things that we could discuss in those consultations. The only time that we could discuss it is if there were legislation needed to be brought forward in detail. If secondary legislation had to have much more detail than is set out as being required in this bill, we could then come to you and say, this is having this impact and we would like you to
Are you aware whether any of your members or you as organisations have raised these commercial concerns, these cost concerns, or the possible impact on innovation with the Business and Industry Department? There's been a lot of discussions with the Home Office, any with business, industry, skills, the email, internet, czars, that you're aware of?
Not at the high level.
So, to our knowledge, no, but then obviously we're not privy to all the communications of our members directly with government departments.
So it's possible that BIS are just not aware of these concerns. It's possible. Okay.
No, we've had meetings with, ISPA's had meetings with BIS and... I'm sure they're aware of these concerns. Okay. We may need to redouble our efforts in meeting with them again.
Right. Okay.
We're not sure that there's political awareness of it within BIS.
Yes.
We've had some. We have routine contact with junior officials on a range of matters and disclose the things that are impacting us and that we're working on and that they share with us, particularly when it comes to international matters as well, on which we've got a strong history of cooperation. This has been raised, so I couldn't say that there's been no contact at all. But the idea that this is being, engaged with, no, I think in the broader sense the answer is no, even though
we'll make
strictly
other
the answer is
inquiries
yes.
and try and get to the bottom of it. Lloyd Strasburger, you. risks?
The effect of this bill would be to create a large number of databases distributed physically about the country, and possibly the effect of the filter would be to make these logically into a central database. Does that inherently have risks of loss of data, of intrusion, or whatever?
Yes.
What are those risks?
Well, anytime that you have required people to keep data, that digital data will be stored somewhere. It will be on a system that needs to be accessible, particularly if the filtering system needs real-time access to the data. It's going to need to be accessible on the internet. There's always the chance, and it happens with some regularity, that an ISP's servers are compromised and data stolen. Even, I would say, perhaps the most technologically advanced and security-conscious company of them all, Google, pulled out of China because of a phishing attack that compromised some of their servers by someone, presumably, I don't know who else other than the Chinese government would be interested in the emails of Chinese democracy activists, but that's never been proven. When even Google, is vulnerable at times, although they're very, very good at this, we do have to have some concerns about every other small ISP, small startup internet service, and so forth. Keeping that data confidential is it's non-trivial. Servers are broken into all the time, and there will be leaks of the data for sure.
Risk is a function of impact as well as likelihood. In terms of likelihood, our industry has a very good record on protecting private data and on protecting their databases from technical attack. But nothing is ever perfect, and sometimes that, problems do happen. But it's rare. It's very rare. But there are other mechanisms, and certainly the thing that concerns us more greatly than technical attack in terms of likelihood is the insider threat. It's the ability to compromise individuals who have legitimate access and get them to misuse that legitimate access. And frankly, we wait to see what comes out of both Leveson and the Operation Alpha Deer, which is directly related to that. But I think we might learn quite a lot from that. And certainly that seems to me a much more likely thing if the motivation is great enough. And then you look at impact and you think, well, how much would people want to get access to this? What could they do with it? And you ask, and I don't think it's appropriate for me in public to go into great detail about all the dreadful things that could potentially be done. But I put skimmed over a couple in my written submission, and if you'd like some more in a private briefing, as to maybe if you have questions about whether that's what we're suggesting or hinting at here is realistic, then we'll be happy to get back to you.
I think we'd probably take you up on that. If you have other information you wish to send us confidentially, and you wish it kept confidential, then we'll respect that. We prefer to see it and hear it and read it, and keep it confidential rather than not get it at all. So if you discuss with officials afterwards, we'd probably like to take you up on that.
Well, I'd like to hear what kind of thing you would like to have then, so we'll conduct that conversation with officials afterwards, certainly. Yeah. What would be most useful?
Can I begin to conclude this? It's been a long session and we're very grateful to all of you. Costs. We've had a lot of discussion on costs. I know I've read your briefs commenting that no government computer contract has ever come in under budget or on budget. We all understand that. Have any of your members shared with you their estimates, their best estimates of what the costs may be, including any legal liability if it goes wrong? Now, if I was one of Apple's 12 million customers yesterday and found my data all in the public domain, then if I was an American, I'd probably be suing already for a couple of billion. But have your members made any estimate of the technical costs?
When we've had discussions at ISPA between the members to try and answer this sort of question, the problem in cost is it's how long's a piece of string? We don't have enough information from government to know what they want stored for how long, which types of data yet. So it's very difficult to put a clear cost on it. My colleague also pointed to the fact that if you are designing future services, the sort of opportunity costs of not focusing on your business and looking at potentially having down the line to store data is another cost we can't actually clearly put our finger on. A good example of this is if we were asked to store third-party data from over-the-top services such as Facebook and Google, the amount of data rockets up and therefore the cost would increase. And we also don't know what the future impact will be of greater data over the next, shall we say, 10 years, which will also impact on costs. So it's actually very difficult to give a very clear answer, but I think generally speaking, whatever the cost will be, it will probably more.
Yeah. My final question to this is then, is RIPA fit for purpose? In that we are now trying, or the government is now trying, to collect a whole range of new information, but using the model of the 2000 Act and the definitions there of content and data and subscriber and so on. If you were starting from scratch, would you have used RIPA as the model, or were you trying to invent some new and better definitions?
If you're trying to provide a framework for efficient and effective covert investigation of electronic communications that also has a coherent and balanced approach to oversight and to establishing norms of proportionality and ensuring that they're complied with consistently, then we don't think that the current definitions are well aligned to supporting, to providing the hooks by which you might impose particular policy judgments, whatever they may be.
And that's the view of the majority of your members?
We believe so, yes. We believe that this is more than the majority, and we believe this is a general consensus.
Okay. Mr. Lansman?
Yeah, just a point to be made. There are different definitions at a European Union level. So within the directive, there are slightly different definitions and meanings used in European directives compared to in UK legislation, and that's another issue to be dealt with.
We can manage with RIPA as it is, relating to only the things that are required to be collected under the data retention regulations, because there's a narrow specified set of data types. But when you start extending it into some of the areas that we talked about here, then it simply doesn't provide the hooks to relate to the intrusiveness of the data.
Is that your view as well, Mr. Lansman, your members?
Absolutely. I mean, if you look at the definition of subscriber, what that meant a few years ago is very different to if you're looking at subscriber details. For example, from Facebook, it might give a lot more information than just name and address.
Yes. Or indeed a lot less information. When you think about subscriber, one of the things that's mentioned is who is the person in control of a particular email account. Well, Google generally won't know that. I just created a new email account to accept RSVPs for my upcoming wedding, and I just signed up for the account and didn't give them my real name. Why should I? Or address or anything else. And so one of the questions that would come to my mind is that if Google is required to cough up the real name of a person controlling an email account, that's going to have significant impact on their ability to provide free email accounts in the UK.
Well, the bill does provide that the under Clause 1, that the Secretary of State could be requiring the collection of certain types of subscriber data at the point of account sign-up, that is not collected at the moment. That's the basis of the third-party collection, is for stuff that you don't already need. But if you apply that to the over-the-top provider at the account creation status, you could say, well, please supply your passport number as well. And that could be one of the things that goes in the notice from the Secretary of State to the provider, that you must be providing passport, collecting the passport information, passport numbers of the people that are signed up for your accounts, making essentially, anonymous accounts or pseudonymous accounts possible.
Okay, I think we're going to stop it there. I'm very grateful to all of you. I'm sorry it's been a long session, but we could go on for another couple of hours questioning you and your colleagues previously. Thank you once again for your written submissions. We will follow up on, if you've any other private information to give us, we will follow up on that. Could I ask the Bill team to stay behind for a couple of minutes just now? We have a couple of points to go over, and colleagues, briefly, we'll just have a very brief couple of minute washout. Thank you all very much. That's very kind. We're going into a quick private session.
Thank you. Thank you.
Committee Room 4A, Sound.